All right, what's going on, man? Yeah, it's just crazy that like I've kind of been doing equity for a while, but not really knowing I was doing equity and getting remedy, but not knowing how to stick with it and keep doing the same thing in repetition. So I'm showing you going back years. Um, that like I said, I guess that's why you entrust me with the information. You do understand I had the capacity to learn it. So I'm just showing that I'm shocked myself. So I'm just sharing this with you, let you see some of the things I've done. Um, so let me just type this in real quick. Yeah, because some of the things I've done, man, and didn't really have a lot of people to speak to this about because not um, everyone definitely in real life, like in my circle of family, I definitely can't discuss any of this with them. And even online, like I don't know, like I understand public and private, but a lot of the times I didn't even have the capacity to want to just get online and share this. So um sharing this with you guys because I know you guys know what's up. So going to the first one, like I said, the year again is 2016. I was doing stuff like this. And I came into this information probably in 2014 probably. But the thing is, why I couldn't receive this information the first time people were giving it to me is because we went into another wormhole. Basically, like we had to unlearn church. Church was a lie. We had to unlearn government authority. That was a lie. We had to unlearn so many things. So I jumped into another wormhole because I had been studying law actively in court for probably 30 years. Yeah, about 30 years in and out court experience dealing with courts and stuff, courts the wrong way. And I started studying first statutes. Then I realized remedy wasn't procedure. So I did start getting a lot of remedy, but it's not until I started incorporating some of the equity practices that things started happening. But it took so long for things to happen that I didn't understand what did it. So so I'm going in here because I always have a hard time finding the email because basically what I did, it wasn't about what I filed. It was I contacted the judges. I forgot what they call that. I think they call it a JA though, judge's assistant. And we started talking, I think by phone. She gave me an email and I sent her something. And when I sent her something, it wasn't instant. I had to like call back, communicate with her. And she said, I said, so, yo, what's up? I gave you a couple time to look at what I sent you. I said, did you get it? She said, yeah. I said, did the judge review it? She said, yes, she did. So she said, I said, so what's the status? What's she gonna do? She said, I'll tell you what. I spoke to the judge and she said, can you send her a physical copy? Can you mail that? What you emailed, can you mail it to us? And I got excited because I was like, it wasn't like she told me I was crazy or she didn't say no. She literally said, send it to me, the physical one. And I kind of understood that they wanted that wet ink. So I did that. And yeah, it took a while. Like they kept going through the formalities. And then I finally called them on the day of court. And I was like, look, I'm not that close to you. If I need to be heading to court, I need to know. But if the matter has been settled for the record, I also need to know. So she said, let me get back to you. She got back to me. I think it was a little while before I had to be in court. Told me, don't worry about coming to court. As you can see on the screen right here, the matter has been no prosecute. So this, of course, I know you're saying it is not the same as getting a discharge. It is not. I understand it, but to me, these were my wins. I've got a lot of stuff no prost, and I felt really confident about getting that done. But so of course I don't have to click into it. You guys already know no pros, but I want to show you the because I believe it's yeah, it should be yeah here. So this is what I filed into the case. Let me see. Correspondence note. I did. I think it's here. Let's open that up. All right. So this is what I filed into the case. did speak of the common law, but I know it's filled with statutes and code. But common law is basically equity goes hand in hand. And then again, kind of denied that they have the sovereign power to for government. So I put that in there. Let's see. And then basically put all this stuff here. Let's see, for the Supreme Court, Supreme hierarchy of authority within the Florida court system. So putting them on notice. Consideration of material facts contained within. I pray that this tribunal grant the relief sought within. Demand for dismissal with prejudice. So put all that together. Had it notarized. State filing instrument. State independent authority. Yeah, I did put that in. So that's very important too. And you actually don't need a notary. I know you guys probably noticed, but you don't have to have it notarized. And this is in duplicity. So this will suffice in place of a notarization. All right, so let me get back to it. So it's yeah, actually it's not going to have in here what I sent to the JA. Let's see, is it here maybe? Yeah, this is hilarious. Look, receive probate. So again, equity, because equity and chancellor, the chancery division is in probate, trust and probate. So customer required to include and file. Yo, they literally kicked me off, bro. I'm sitting there looking at the screen like, yo, what just happened? But I guess they don't like me showing and talking about this, and maybe it should have been sealed like equity. But that's crazy. It just threw me off of it because I'm here and I'm recording on it. All right, so let me go back in. All right, so there's that one. Where's the other one? I think it was here. Yeah, especially when I started talking about this, including file, copy of birth certificate. So let's see, motion request for hearing. Go ahead, click it for they do it again. All right, maybe this might be it because I did mail it in. No, it's another one. Constitutional challenge to a statute. But I am getting to equity right here. It's talking about just the power of the state shall be vested in the Supreme Court. So courts, no courts other than those herein specified shall be established in this state. So letting them know that no traffic courts, none of that. They're without power to act or to give judgment. Also included this here. So that is not what I'm looking for. Hopefully it's still up. All right, so cancellation notice, criminal cancellation notice. So maybe which one I clicked first? I think it was the bottom one. So click this one. I think they're the same thing. Yeah, what I sent in, I don't think, let me see if this is it. Because actually, no, it's probably not because it was only one page. All right, but I did send in the birth certificate. I did the assumed name thing that everyone was doing around that time. So I put that in, let them know it's a fictitious name, put the birth certificate to back it up, which is the bond. And then I certified it. So it's got a certification, which is very important for records to be considered by the court. But yeah, I would have to look through my emails again. I forget how I look it up. But yeah, I have the email exchange back and forth from the court. Let me see. Actually, I might know how to look it up again. All right. Judicial officer. And the equity party information is important too. Set the copy. The defendant called defendant. It definitely was calling me back and forth, send copy of deposition to defendant. Yeah, because I had called and asked. It says no process. I said, you serious? I was like, yo, let me see it. Let me have proof of it at least. For proof of filing constitutional order. All right, so let me see if I can look this up. right, I think I found out how to look it up. Let me see. I'm gonna look it up right here on screen so you guys can see it. All right, so look at that letter rogatory. I don't know if that's it though, but I sent them this, intent to sue, injunctive relief, demanded. But yeah, it's filled with codes. It's got a bunch of other stuff, letter rogatory relief. Trying to see that letter that I sent her. No, that's something else. That's not it. So yeah, it had to been in 2016. So that's 16. Um, yeah, I can't find it. I don't want to make this video too long, but I was just trying to show that that other thing. Oh, actually, here it is. So this is what I sent them. Good day, Shannon. Per our discussion, I have enclosed written notice autographed under my hand and sealed with regards to the matter scheduled for June 28th at 1:30. Kindness regards. And then I had a little stamp that I made, secure party. Then got the address to them. Know all man bodies presence. Greetings. Come now, Craig Myrick and Surrey Jewers, just solely giving notice of abatement of action with regards to, these are both for the citations. For valuable consideration received, I accept these presentments to witness in exchange for post-settlement and closure of the above bonds and accounts in escrow in the name of Craig A. Myrick. And then hit him with some codes, hit him with the Clearfield Trust, and then beneficiary. So I'm laughing because I'm looking at it. Everything that I was doing was in equity. It wasn't exclusive equity, but it wasn't equity. And then had this. So this, then I put the amount, signed it, and this is when she got this. She said, send it to her. This right here is also where they said I had them deposit the birth certificate with probate. So if you open it up, it's my authenticated birth certificate that I sent in that people don't know we should be using to discharge obligations. So we got the whole full thing in color, state file number right here. And that's a amendment and affidavit of ownership. So I sent them that with this, and I think, yeah, that was it. And that's what got this case done. She basically mailed it in, and she took care of it. So that's on both of those cases. That's the end of the video. Yeah, it's under 15 minutes. I didn't want you guys here watching this forever. Peace.